Hey everyone, I'm Mike Connors, and this is How It Ticks, a podcast about the systems, stories, and ideas that shape life in Switzerland. My guest today is Nora Markwalder, a former prosecutor and now a professor of criminal law and criminology at the University of St. Gallen. Her research spans homicide, domestic violence, white-collar crimes, and criminal procedure. She's also the co-author of a widely used textbook on Swiss criminal law and the co-editor of the Basler Kommentar Verwaltungsstrafrecht, or Administrative Criminal Law. Switzerland has low incarceration rates and high trust in institutions, but what does the justice system really look like in practice? What happens from the moment a crime is committed all the way through to trial and sentencing? And how do Swiss incarceration numbers stack up to neighbouring countries like France or Germany, or common law countries like the UK, Australia, and the US? In this episode, Nora explains the phases of the Swiss criminal justice system, the emphasis on rehabilitation over punishment, and how juveniles are treated completely separately under a controversial juvenile justice framework. We also look at crime trends over the past 30 years, what life is like in a Swiss prison, and the impact of a criminal record when searching for employment after serving a sentence. Now, here is my conversation with Nora Markwalder. Nora, thank you very much for joining me.
Thank you for having me here.
Why did you choose criminal law as a profession?
Well, maybe it's a bit of a family business because my father worked as a coroner, like a legal medicine specialist, and I was in contact always with this world. And I was also very interested as a young student with the area of like profiling serial murders. So I really liked that and was interested in. So for me, it was clear that I wanted to go into these fields, and I already knew I wanted to do criminology. And for that, in Switzerland, you can't really study that. So you have to do studies before. So I decided to study law, and that became this mix of criminal law and criminology that I'm currently doing.
I was going to ask you later if you ever wrestle with switching off from work if you're dealing with crime and murder, but if you are someone who loved to get into that detail, perhaps the answer is no.
Well, yes, I can already tell no, because I'm the kind of nerd who even likes to watch like crime TV shows and stuff at the end of my day. So basically, no. I have a hard time, separating these like kind of work-related interests from private interests. It kind of grows into each other, I guess.
Interesting. Wow. I guess you landed the perfect job.
Yeah, I think so.
So, the Swiss legal system, can you explain to me, as someone who is very unfamiliar with it, what the different phases of the Swiss criminal justice system are? Really from the beginning, from an investigation through to someone gets sentenced or, sentenced.
Yes, exactly. That's kind of like the ending point. And at the beginning, it just starts with a police investigation, or basically the police are getting, in contact with someone, or someone else is, telling the police something happened. And then there's an investigation that is the prosecutor, actually, who is the head of this investigation, and the police is working with the prosecutor. But it's a big difference between the continental European law systems like we have in Switzerland, or also in Germany, in Austria, in all the surrounding countries, and in the US or common law countries, is that the prosecutor is actually leading the investigation, but the goal is to just look for what happened, look for the truth. So they investigate in favor of the defendant as well as against. So it's kind of like a more of a neutral viewpoint, and something completely different from what we see when we watch US TV shows, American movies. But that's the kind of the main role actually of this investigation is the prosecutor. And then you of course have the defense attorney, you have maybe some civil claimants that have maybe also some interest. And then the prosecutor leads this affair until he or she decides to bring this affair in front of a court. So they try to charge, or they decide to charge someone, and then it's the court actually who decides whether or not the person is guilty. And then, according to the verdict, you maybe get sentenced to a prison sentence or some other sentence, like a fine, like a monetary penalty. So these are the different stages, but the stage of the prosecutor and the prosecution is actually the most important one, because most of the time when there are some minor cases, the prosecution can decide whether or not they want to punish the person themselves, which means they can order a penalty order, which is like a summary proceeding. And most of the time, the cases in Switzerland, they get resolved like that. So a lot of the cases don't even go in front of a judge.
Mm-hmm. You said that the prosecutor looks at them both favorably and unfavorably, so very neutrally.
Yeah.
Is that
Yeah.
comparable of in the US, it would be innocent until proven guilty? It is that how are they looked at before they're charged?
No, because that's a rule we actually also have. It's the rule that the court is required to follow, that if you are not really sure about whether or not someone has done something, then you have to acquit. And in case of doubt, you shouldn't go any further. But here it's really the role of the prosecution is considered to be a completely different one. It's not someone who is trying to convict a person. So the ultimate goal is actually a conviction, but it's really someone who has to establish what happened. And just right at the moment where the prosecutor actually then brings the case to court, this role switches and he or she becomes actually the like one party side, where they have to defend their point of view, in sense of that they think that the person is guilty. But it's a completely different mindset actually from common law countries.
If the prosecutor isn't trying to prove them guilty, and they are just trying to tell a story, how different then is the role of the defending lawyer?
Well, it is actually still a very important role, because as in like Anglo or common law countries, of course, if you already have some suspicion and the case is opened, the prosecutors are also a bit, let's say, biased sometimes about, how the case should go and whether or not someone could be guilty. So the defense attorney still has a very important role of asking other questions that might not have been asked. He or she can also ask for new evidence that is going to be collected. And in Switzerland, the evidence is going to be collected by the prosecutor or the police. So basically, you don't need an investigator or something, but you can just ask for new evidence to be collected. And in general, the prosecutor agrees to do that. So it's a different role, but it's still a very important role, because even though we have this rule of looking in all ways and investigating in all directions, it's still good that the defendant has someone to defend his interests and to make sure that his interests are also considered.
Is there ever a jury in Swiss law?
Not anymore. It used to be back in the days, 15 years ago, the criminal procedural law was cantonal. So it was not for the whole Switzerland, but just for the different cantons. And some cantons had a jury system, like the canton of Zurich, for instance, had one. But then starting in 2011, the Swiss Criminal Procedural Code was entered into force, and that was for all Switzerland. And since then, there is no jury anymore.
And how is it decided whether a court, whether it will be taken up in federal, cantonal, or local court?
Usually it's always in the cantons. So basically every case that happens, for instance, if you are, involved in a robbery in the canton of Zurich, then it's the instance from where you committed the robbery that is competent for your case. There are just a couple of exceptions where there is federal competency, like organized crime, some company crime related things, explosives, some sort of things that are on a federal level, but usually it's just the cantons that are competent for the criminal or the execution of criminal law.
You said that there's a lot of similarities between other European countries. Are there any unique differences between Switzerland that stand out compared to Germany, France?
It's not really regarding the system, because the system is quite similar. Also, the role of the prosecutor is quite similar. What is different is that there are very few cases in Switzerland now that are brought in front of a court. It's this possibility of a penalty or penal order that is very, very often applied in Switzerland. And I think that's not the case in other countries where they have a bit more cases that are brought in front of a court. And what's also a bit different, at least regarding a system like Germany, is that our court days are shorter. So if the case is in front of a court, usually even a bigger white-collar crime case maybe takes 2-3 days of, deliberations and hearings, etc., in front of the court. And in Germany, for instance, that's much longer because all the evidence has to be repeated, all the hearings have to be repeated in front of the court. So that's also a bit of a different system, at least in regard to Germany. But otherwise, like the standards and the competencies, also the role of the prosecution, the police, etc., the court, it's more of a European thing, so to say.
Are there any types of crimes that happen proportionally more in Switzerland than other countries?
Not that I know of.
That's good.
Well, actually, one would say maybe, white collar crime, that's maybe more, at least it's not what we see in the statistics, but that's a crime that is very much in the dark, often where we have not a lot of information. And this, of course, it's a situational factor. Obviously, if you have maybe a lot of industry banks, etc., then maybe also a bit more of an opportunity to commit some sort of crimes. But if we compare internationally, we are a very safe country. We do have very low crime rates. So it's more like the opposite, that we have crimes that are not as often perpetrated in Switzerland as in other countries, but it's in general.
I looked up incarceration rates in different countries, and so looking at the statistics from the World Prison Brief, incarceration rate per 100,000 people. I'm sure you're familiar with these statistics, but Switzerland at 73, Germany at 67, so actually slightly lower. France 109, UK 132. I threw Australia in there, of course, 158, and then the US a whopping 541.
Exactly. I mean, I think with the US, no one else can really
Gotta be number one at
get.
Everything.
Yes, it's really the number one. I think even higher than Russia and maybe China or so. Yeah, Switzerland really has a very, very low incarceration rate because our system is not punitive at all, meaning that we don't have high prison sentence that we usually foresee for offenses. Our main penalty is actually a monetary sanction. So if you don't kill anyone and do really a serious crime like a robbery or maybe some really serious assault, then you usually, as a first-time offender, you get a monetary sanction. So that's our prime or first-hand punishment of choice. And the prison sentence is really just either for very serious offenses or repeat offenders that really haven't learned their lesson. So that's also the reason why we have so few people in the prison system, because we're very selective. And when you look at the prison population, that's really quite a heavy charged population of really either serious offenders or repeat offenders.
Where is the line between when you're no longer giving someone a monetary penalty and you're really, okay, you know what, you have to be in prison?
Well, actually, the monetary penalty is up to 180-day fine. So we have a system, the monetary penalty, that you have like the days that count for the seriousness of the offense. And then per day, you have like an amount that you get charged, and that's based on your income. So it's income related. And the maximum you can get is like 180 days. But that's a very low number for everyone else than Swiss or people from the Swiss system. So that's actually everything else. If you want, for instance, you think like that's like a year of penalty or 2 years or 3 years, then you don't have this monetary penalty anymore. It's just like 108 daily rates, and that's very few. But we do have in our penal code quite a flexibility in every offense in regard to what punishment is adequate. So the judge or the prosecutor has a big amount of freedom to decide whether or not, for instance, for this robbery, maybe that wasn't a very, very serious one, or maybe for this burglary, it's enough to have like 120 days of monetary penalty. So basically, we have in the statistics, we see that around 95 to 98% of all criminal cases get resolved through summary penalty order, meaning by the prosecutor. So that shows you that we have very lenient sentences and very few sentences or cases where you really have to get a prison sentence.
So is the daily rate a fixed rate? So that's essentially a percentage of your income. Is that fixed, or can that also be variable?
It is variable depending on your income, and usually it's not only like the income from your day-to-day work, but it's also all the other revenues that you have. So if you like are maybe very rich and you don't really work, but you have a lot of money, then it's considered also during the calculation of this daily rate. And the idea behind is really that it should be socially just, so that the monetary penalty actually kind of hurts everyone a bit the same, regardless of their financial background.
How does Switzerland factor in or even prioritize rehabilitation? My understanding is Switzerland's also quite good with really using rehabilitation as an outcome of crime.
Exactly. So it's a priority, and that's also a bit visible with this very large application of the monetary penalties, the fines, because we believe that this is less intrusive and less damaging for someone's re-entry into society than a prison sentence. So what we wanted to do a couple of years back is really eliminate these short prison sentences, because it was supposed to be somewhat bad for the rehabilitation of offenders. And the prison sentence really we call it ultima ratio, so the last resort basically for someone. And if we can avoid, we try not to sentence someone to prison, or maybe a conditional sentence where you just kind of get the warning that if someone repeats the offense, then you have to go to prison and stay there. So it's usually the system also with the monetary penalties is conditional, in a sense that first time offenders, they get the warning like, okay, you are convicted, but it's you don't have to pay the fine, or you don't have to go to prison, because it's suspended. The prison sentence is suspended, or the fine is suspended.
What forms does rehabilitation take?
Well, in the sense that we try not to send people to prison. That's
Mm.
like the first form. In a second is people who are in prison try to be prepared to be released from prison. So basically that means educational programs in prison, also work possibilities in prison. Swiss prisoners are required to work. So it's an obligation, but actually everyone kind of likes it, because otherwise it's very boring
Mm.
and you can earn money and have something to do. So, but there's this possibility of education, and it's also possibility of therapy. A lot of the offenders that end in prison have committed serious offenses, and usually there's also some psychological trouble involved. So they most of the time, for serious offenders, like serious violent offenders, they do also have a therapeutic measure that they have to comply with. And this is also something that tries to eliminate the risk of recidivism that can happen with these offenders. So it's several ways of trying to think while being in prison about what happens when they get out.
And when you say work, so they're doing jobs within the prison itself?
Yes,
Mm.
yes. Usually this is kind of work in the kitchen
Mm.
or manual labor, where they do some reparations maybe, or some other manual labor. There are different ways of doing work. It depends also on your sentence and on the stage of your prison sentence. Maybe if you're in an advanced stage, and it's not, you don't have to fear that people are maybe dangerous. You can also work outside the prison sometimes. So there's a lot of flexibility depending on the person.
Are there different level of security prisons?
Yes, there are. It's some of the standard prisons that are really like higher security, meaning people can't get out. And there are some facilities where you have like people that can even work outside the prison or have their normal jobs, and then they go back in the evening. So there are different modalities and different ways. And according to your risk, it's you either are in the regular like high security facility or you are in the more flexible one.
What is the longest or the worst sentence someone can receive?
For the sentence, it's lifelong imprisonment. We also do know that one, but it's very restricted to a limited number of offenses, such as murder, for instance, and some other very selected offenses. What is more serious, I think, is not really the sentence, but the measures that can accompany a prison sentence, because we have some measures that like therapeutic measures that can be prolonged, that can be added and can make that even though you have finished your prison sentence, you remain in prison because you're still dangerous. And that can be for some measures, that can be for life, basically. So
Mm.
some of the offenders, even though they have finished their prison sentence, they don't get out anymore and they stay in for life because they still consider to be dangerous.
I see. And from your experience, is it realistic for someone to come out of prison with a permanent record and go ahead and get a job and resume their life?
Yes, yes, because that's also something that is completely different from the Anglo-Saxon countries. I don't know how it is in Australia, or I know just from the US, where it's very like discriminatory if you are having a record. And in Switzerland, actually, this is not really that common that an employer is actually asking for your criminal record. Some of the employers, obviously, if you're in finance or if you're dealing with children, etc., then yes. But for regular, I think manual labor, etc., it's not really the standard that employers asking for the criminal record. So the integration actually and rehabilitation of offenders is also helped by this. So you don't have restrictions in regard to work or housing or other things. So this is really quite helpful for the reintegration of offenders.
Hmm. Actually, I heard the term restorative justice recently, where, and I didn't know about this, but victims and offenders can sit and actually talk to each other to try to repair the harm that's been done. And especially, I guess it's more common in smaller cases. Is this common in Switzerland?
No, because our system is also repression. You know, it's the state who is punishing you for some wrongdoing. So this is a very it's a question of mentality. It's actually interesting because Australia has a very big culture of this reintegrative way of doing justice, you know, but it's more culturally also related to the Aborigines culture, I heard. So Australian researchers actually have done a great deal of work on that, but it's very cultural dependent. And for the Swiss culture, it's still in our minds that there's someone who has done something wrong that needs
Mm.
to be punished. And the victims' interests are not really that important, actually, even though it's their, you know, they've been wronged or they've been harmed. But the victim in a criminal procedure is often a bit neglected because it's really state versus defendant, and victims' interests are a second, you know, come second. And there are some, yeah, some researchers in Switzerland that try to push this agenda of restorative justice. They try to make the process a bit more inclusive also for victims' interests. But it's a project that is currently ongoing where they try to look where they could situate this a type of kind of dealing or negotiating with all the parties to the process. And it's a big discussion whether that should be done during the proceeding or after the verdict. And that's not quite clear where to put that.
So the victim really doesn't have a big role to play during the whole process.
Not really. What the victim can do is they can participate in the process. They can ask for damage, you know, that like money that their damage covers. So, like civil claims at the same time. That's kind of their role. But other than that, they can't really ask for a high sentence, that you can just ask that the offender gets punished and that their damages get covered. But more than that, no, the system doesn't really care or is not really interested about also the maybe psychological harm or maybe the negotiation also between victims and offenders. So it's really another focus.
Is there systems in place to prevent wrongful conviction? So new evidence comes out later and then all of a sudden you realize, oh, we've done something wrong. What happens in that situation in Switzerland?
There is a possibility to reopen the case, but only in cases where you really have some new evidence coming up that wasn't known before. And then you can reopen the case, reevaluate the case, and also make the verdict or the conviction go away. But it's very rare. And at least from the cases we
Mm.
know, and here also, I think the dark figure is probably much higher because of this proceeding that I've mentioned, the summary penalty order. This is a proceeding where the prosecutor just haven't, in most cases, haven't even seen the defendant. So they just get like the verdict sent at home. It's like a written proceeding. And a lot of people, they don't really look at the verdict. They don't really understand it maybe. And then they just do nothing. And if you do nothing, you get convicted. It's like a regular verdict. And there we know from research that the error quote or the error proneness of this proceeding is actually higher than if you go in front of a court. So this is a bit the risk of wrongful convictions comes in these types of constellations.
I'm just thinking, how complicated do the different languages make the courtroom?
Yeah, I mean that's a big issue for the summary penalty order proceeding, especially people who don't know the local language, they don't understand. And legal language like legal German or legal French is really complicated. I mean, even people with native
Okay.
language skills are not able to understand what actually we are writing. It's a terrible thing. And we lawyers are terrible in writing so that everyone understands us. But it's really the language problem adds but it's very specific. I mean, it depends on the canton, like in the canton of Zurich or the canton of St. Gallen, it's clear that the official language is German. So you need to speak German. And if you don't speak the language, then you get a translator. So if you're a defendant and your language skills aren't good enough, then you have the right to have a translator. So you don't have like several languages spoken in one courtroom or at the prosecutor's office because it's clear from the beginning which language is going to be used. If you are in a French-speaking canton, obviously the procedural language is French. Or if you're in the canton of Ticino, then it's Italian. So it's always clear what language is spoken. And even on the federal level, it depends what area the case is situated. It can either be like German speaking or French speaking or also Italian speaking.
Have you seen the movie The Anatomy of a Fall?
No, I haven't.
Ah,
No.
no, it was a Swiss-French production, and it did very well. It was a
Okay.
murder-based courtroom drama, and it was.
Oh, okay. I have to watch that.
I'm curious because they
I-
jumped languages throughout that film, and I wondered how realistic that
okay.
is, or maybe it was just a flex of the actors.
Yeah, well, usually on a federal level, it's not in a courtroom, but for everything else, if you are in a federal level and you are in a committee, everyone speaks their own language. So basically, if you're in a committee with a French professor, French-speaking professor, and an Italian-speaking and a German-speaking, then everyone speaks their native language, but the other one responds in their native. So basically, it's a bit of a Babylonian language thing, but it works quite well. But in a courtroom, it's really decided and it's precisely put ahead which language is going to be used.
That's it for part 1 of my episode with Nora, but be sure we are not done. Come back tomorrow for part 2 as there is much more to still unpack. Stay tuned.